supported the case law authorities. So they are doing classification of contracts.
Okay.
If you are ready, you may start.
Good morning, everybody. Good morning. Okay, we are the Unnamed, and today our presentation is going to be on the classification of contracts. Toby JCA defined contract as an agreement between two or more parties which creates reciprocal legal obligations to do or not to do particular things. Also, in Akinyemi versus Odua Investment Company Limited, the Supreme Court defined contract according to Black's Law Dictionary as an agreement between two or more parties creating obligations that are enforceable or otherwise recognizable under the law.
In other words, this piece can proceed to define the term contract as an agreement which the law will recognize as affecting the legal rights and duties of parties. Having removed the marks between the concept of contract, this piece will, in subsequent paragraphs, discuss extensively the classification of contracts.
So first, we have the formal and informal contracts. The 12th edition of Business Law, text cases Clarkson, Miller, and Cross says that formal contracts are contracts that require a special form or method of creation to be enforceable. A formal contract can also be seen as a classification of contracts that is in writing and where the parties have signed under seal, while an informal contract is one not under seal. A seal can be any impression made upon the document by the parties to the contract. Historically, this was traditionally done in wax, stating the intentions of the parties to be bound by the contract. Only parties to a sealed contract are the people who have rights under it. Thus, only people party to the contract can be found liable. According to Habibola J.D., Professor of Law at Loyola University, roughly 100% of contracts today are informal contracts.
The legitimacy of a contract, however, does not rely upon whether a contract is formal or informal. Both are considered binding given all other elements of the contract exist, in which both parties agree to each comply with each other's wishes to a certain limit. Usually, the contract is formed by a greater authority, such as government, corporation. In a formal contract, it uses negotiable instruments such as checks, drafts, promissory notes, and certificates of deposits.
Moving on to informal contracts. An informal contract is a type of agreement that will not require any sort of legal intervention to be considered enforceable. In Rand versus Huggs, it was derived that a promise or agreement not under a seal is not actionable unless there be consideration for the same, even if it be in writing. Informal or simple contracts are different from formal contracts because they do not need to be sealed, witnessed, or written. This type of contract is often called a social contract. Contracts in this classification need to be avoided if there is no trust with the other party you are contracting with. A verbal contract is considered informal and only works where the other party can be trusted to perform their contractual duties without a written assurance. An example of an informal contract that is most common is a sales contract. They are specific to every situation and will not always include specific legalities. For instance, a sales contract will not be the same when buying a used motorcycle versus a brand new one. It could also be different if two people were buying the same motorcycle or in a different color. Everyone's contract will be completely different based on individual circumstances.
For it to be legally binding, an informal contract must include mutual assent, offer, and acceptance and consideration. It is not based in formalities but in the observation of people making promises and intents. Finally, there are 5 main elements that should be considered when forming an informal contract. These are mutual assent, consideration of validation, two or more parties entering a contract, parties must have legal rights to contract, and lastly, no statute or rule declaring a contract void. Then we are going to move on to express and implied contract. When a contract is described as express, it means that the contract is clear and what is intended is expressly stated. An express contract is the most common type of contract. The extent of the respective obligation of the offerer and the offeree are clearly stated either in writing or orally. Either way, offer, acceptance, and consideration must bind the parties together legally. The parties involved must understand and consent to the terms and conditions of the contract explicitly. In an express contract, the same applies. For instance, in the sale of a phone, the offerer gives their required price and the offeree accepts. Once acceptance is made and consideration is exchanged, the contract is binding and enforceable as long as both parties uphold their promise. An example of that is in Thomas versus Thomas. Then for implied contract, the terms of the contract are not expressly or clearly stated, but the court will infer the existence of the contract from the conduct of both parties, and this can refer to parties acting on unsigned terms for a period of time, like in Brodging versus Metropolitan Railroad Company, and also in AG Cardinal State versus Victor Bassi.
So for bilateral and unilateral contracts, basically a bilateral contract consists of an exchange of promises. A bilateral contract is a legally binding agreement, typically in writing, with terms and conditions negotiated between two or more parties. A striking example is the case of Sumter versus Hedge. Then also moving on to a unilateral contract, where we can find a striking example in Calio versus Catholic Snowball Company, and also in Brodging versus Metropolitan Railway and Weatherby versus.
Thank you very much. Thank you very much. So now we move to the question and so now we'll move to the question and answer section. Please, do you have a question? For them. Do you have a question? So I have about 3 questions here. Number 1. I do have to do answer questions. So number 1 is that.
Did I want to ask the question? Anybody can answer?
Yes, anybody in the group can answer. So number 1, for contracts under seal. What distinguishes a contract under seal from other types of contracts?
This is oh, sorry. I thought you're asking us generally. Sorry.
Take both of them. Thank you. So what distinguishes a contract under seal from other types of contracts?
So, what distinguishes a contract under seal is that it doesn't have any consideration. There's no consideration there.
Another one is that. Another question. The consideration in unilateral contracts and bilateral contracts are oftentimes confusing. What is the distinction between the consideration of unilateral contracts and the bilateral contracts?
Okay. For unilateral.
You have to be honest. You have answered the question. Another person.
So she can answer.
You have answered one now. You guys are following.
The difference between constitution and unilateral and bilateral contracts. Well, in unilateral contracts, consideration can be the benefits or the detriment suffered. Is that what you mean?
No. That's not correct.
Okay. Can I rephrase the question?
Okay. Is it, let me help you, is it executory or executed?
Yes, that's what.
Okay.
You are not the one answering the question now. In unilateral contract, the consideration is
Unilateral
what?
is
Executory, and in
Then in
bilateral
bilateral
is
is
executed.
executed.
Please take the question. Thank you very much. Do you have any question for them? No. So the next group.
Say your name.